Hello, everybody. Today is February 21st, 2021, and this meeting is hosted by the Hearing Loss Association of America, the Boulder chapter. Our guest speaker, Spencer Kontink, is an experienced trial lawyer who happens to have hearing loss that began at the age 12. His family is very supportive and volunteers with the Listen Foundation. The Kontink family raised over $150,000 in an extraordinary quest swimming in a relay across the English Channel. There are adorable photos and a video to view on the Listen Foundation website. He is now a Denver attorney who specializes in disability discrimination litigation. Spencer was one of Chipotle's trial lawyers in a high-stakes, multi-million-dollar lawsuit. In 2021, Spencer found himself excluded as a juror because he is deaf when he reported for jury duty in Denver. In 2022, Spencer and Colorado Cross Disability Coalition filed lawsuit claiming the court violated Colorado Anti-Discrimination Act. On January 23rd, a Denver District Court judge dismissed the case the day before the trial was to begin. So last year, also, Spencer stepped in to fill the shoes of the late John Waldo as legal counsel for the Association of Late Deaf and Adults. Today, I would like to spotlight Spencer so we can hear it from him exactly how he feels about his case and what he plans to do to turn this wrongdoing into something that the courts might make it right. He's in a position to discuss that now. Let's welcome Spencer.
Okay. Well, thank you everyone for having me to talk to you tonight. I really appreciate the introduction, Terry. There was a lot of stories that I think I can tell based on that introduction, but I'll try to keep this focused on the lawsuit and tell you a little bit about that. I also want to invite you all to ask questions as questions come up. As Terry mentioned, I'm an attorney. I do a lot of work in, deaf and hard of hearing cases, but I do a lot of work in disability discrimination generally. So, if there are questions that you have or there is information that I can share with you that would be helpful for you in the group, I'd be more than happy to take some time to try to answer questions that you guys have. But bringing it back full circle, I have a hearing loss in my right ear. I have a profound hearing loss in my right ear, and I am deaf in my left ear. I lost my hearing in my left ear when I was 6 years old. I was hit in the head with a baseball bat, and so my bad ear became my good ear. And I grew up with a hearing family. I learned a little bit of sign language, but I have always relied on spoken language. I think for a lot of my childhood and young adult life, I tried to distance myself from anything related to disability in any way, shape, or form. I was, a little bit embarrassed about having a hearing loss, and I didn't like being associated as someone with a disability. In law school, and when I started practicing law, I think I sort of came full circle and I realized that I was in kind of a unique position to be able to help and work with individuals who have disabilities based on, kind of my personal experience with it. I think that gives me a little bit more empathy and understanding in terms of the struggles that some of my clients face. And I realized that I kind of have a unique ability to be a bridge, for a lot of people who may not realize that the actions of their companies or, their individual actions, the effect that that can have on, disabled individuals and hard of hearing individuals. So in the summer of 2021, I believe, I was called in for jury service. It was a Denver County Court case. It was a one-day jury trial. And before I showed up for jury service, I filled out the form and I requested a CART interpreter. I'm sure you guys are familiar with what a CART interpreter is. Just in case you don't know, it's essentially, real-time transcription of everything that's happening in the courtroom. And so a CART interpreter was there with me when I showed up for jury service in the main room. So you show up and you go into a big room with, a couple hundred people, and they play a video and they give you an introduction about the importance of jury service and what it means to our justice system. And so I had the CART interpreter for that, but then I got called for jury service as juror number 1 in one of the courtrooms. And so we were escorted to the courtroom. And I was super excited because I am an attorney. I try cases to juries. I have tried cases to juries. And I would love, love, love the opportunity to serve on a jury. One, because it's my civic responsibility, and I really believe in our jury system and our criminal justice system. But two, I just think as an attorney who practices in front of juries, it would be a really unique experience and opportunity to be able to be on the other side of the trial and obtain information from, the witnesses and lawyers and be able to evaluate that process. So I was very excited about the opportunity. The CART interpreter and myself and about 20 to 30 other prospective jurors, we were all standing outside of the courtroom waiting to go into the courtroom. And the CART interpreter asked me, Spencer, do you mind if I go ahead and go in and get set up so that we can get started right away when you come in? And I was like, no problem. Not an issue. I'm pretty comfortable communicating with people one-on-one, so that wasn't a concern of mine. For me, it's just challenging when I'm in a big courtroom and there are a lot of people talking and, maybe there's other noises. That's where I really tend to struggle with my hearing. So the CART interpreter went into the courtroom, she got set up, and a couple of minutes later, she walks out and she tells me, you're free to go. And I look at her and she could tell from my face that something was wrong. I was very confused. On the one hand, I was like, okay, well, I'm free, I'm good to go. But on the other hand, I was like, what do you mean I'm free to go? Nobody's talked to me. Like, why don't I get to have the opportunity to serve on a jury? And so she told me that the judge, the DA, and the PD had agreed to dismiss me, because they were worried about my ability to be a jury because I had a CART interpreter. And so as I'm walking out, I see the other jurors looking at me, and I think, initially I felt like frustrated, but then that quickly turned to like anger, and I was pretty angry about what had happened. I spend a significant portion of my practice advocating for people with disabilities, and this was a situation where the Denver County Court was basically sending a message to everyone there that it is okay to treat somebody differently because they have a disability, because they have a hearing loss. And we had the CART interpreter there, so it wasn't like the accommodation wasn't there. They had it. They just didn't want to use it. And so I was pretty frustrated and pretty distraught about that. I sent a letter to the district attorney, which is the prosecuting office. I sent a letter to the public defender, which is the attorneys who were defending that case. And I also sent a letter to the district court judge. And the prosecuting office and the public defender, they both settled pretty quickly. I think it was for 3,000, 6,000, between 3 and 8,000, something like that. And that money was donated to the Deaf and Hard of Hearing Bar Association, which is actually how I know John Waldo, if you guys are familiar with John Waldo. But the Denver District Court was adamant that they didn't do anything wrong, and they were unwilling to engage in, settlement talks, which is pretty frustrating because I wasn't asking for anything like significant in terms of I didn't want money for myself. I wanted a small amount of money to be donated as a recognition of, how they screwed up. And ultimately, Denver was like, we're not gonna settle. And so I was faced with the decision about, do I want to pursue legal action or, do I want to kind of let this go? And I think for me, I was very nervous about doing this because I practice in front of the judges in Denver, and so I had some reservations about being essentially suing a judge, and having other judges potentially retaliate or not look at what I'm doing in a positive light. And I was a little worried that that may affect me or my clients down the road because, they'd be upset that I'm suing a judge. Ultimately, though, I had a discussion with my wife and, I talked to her about it and I was like, I tell clients every day that they need to have the kind of will and audacity and strength to stand up for themselves and file a lawsuit and take action. And if I'm going to be telling my clients that they need to be doing that on a day-to-day basis, then I need to be willing to do the same thing. And so that's really kind of, once I thought about that and processed that, it became abundantly clear to me that it was like, this is what I have to do, and I have to see this through because I need to practice what I preach to my clients when I tell them to do the same thing. And so that lawsuit lasted about a year, and it was set for trial on January 16th, and the day after Martin Luther King Day. And it was a hard fought case. Denver was adamant that they didn't do anything wrong and refused to, really acknowledge the harm that they caused. And so unfortunately, on December 15th, which is Martin Luther King Day, the judge in the court dismissed the case. It was a huge bummer because the court held that the actions from the court, so it's weird, the court held that the court's actions, so the judge held that what happened was discrimination. And the judge held that what happened was a violation of the Colorado Anti-Discrimination Act. The judge also said that declaratory judgment or allowing us to prevail was not necessary because this is likely not going to happen again. And so the court dismissed the case. And, for me, that was very frustrating and disturbing. And I think it sheds some light on why what I do and what organizations like HLAA do is so important, because I promise you it will happen. If you think about what happened in this context, we had a judge, a district attorney, and a public defender, and all three of them who are attorneys, who understand what the ADA is and what it means, decided on that day that the right course of action was to dismiss a juror without ever meeting him and talking to him and knowing who he is and figuring out whether he has the ability to serve. They decided that the right course of action was to dismiss that juror. So three attorneys independently and then collectively made that decision. And so for me, I'm like, if three attorneys who have been through law school and have had to take the bar exam and have had to demonstrate that they have a minimum knowledge of the law, if three attorneys can make that decision, how many other people are making that decision all the time on a day-to-day basis? And I think that just highlights the importance of these cases. And ultimately, I mean, I disagree with the judge's holding, but I think we're going to be able to accomplish a lot out of this. So I had a lot of thoughts about, is this something that I want to appeal and I want to take up to the Colorado Court of Appeals? And that is certainly an option, but ultimately, right now, I'm not sure if you guys are all aware of this, but the Colorado Anti-Discrimination Act is essentially the equivalent of the Americans with Disabilities Act. But the ADA is federal law, and the Colorado Anti-Discrimination Act is state law. And right now, Colorado is in the process of basically rewriting the Colorado Anti-Discrimination Act. And so I happen to know some of the people who are on the committee rewriting that statute. And I think right now, my thought process is we can accomplish more through legislative action than we can through overturning one case, my case. And so we've been able to use my case as sort of a rallying point to get the people who are rewriting CATA to pay attention to the deficiencies that we have in terms of remedies that are available when discrimination like this occurs. So right now, we're in the process of rewriting that bill, and I am fortunately in a position where I have the ability to have not oversight but input in terms of making sure that Colorado is going to have legislation that is going to protect hard of hearing individuals, but I think really more broadly than that, all individuals with a disability. And so that's where we are in terms of my case. I can tell you I do a lot of deaf and hard of hearing discrimination work, and so I see this come up in a lot of different contexts. I think jury service was one context where it has come up. I think that was very frustrating because the discrimination was coming from other attorneys in my profession, and that was really hard for me to just recognize and accept. But I think we see this in a lot of other contexts as well. I have a lot of cases where we have individuals who go to hospitals or doctor's appointments and they struggle with getting either CART interpreters or ASL interpreters, American Sign Language interpreters, for medical visits. That is another area where I see a lot of issues. I see a lot of issues with captioning in movie theaters. I know this is a big deal for a lot of members in the HLAA. I think that is a very challenging issue, because a lot of times, in my experience, movie theaters are a lot of movie theaters, I think, recognize that they have the obligation to accommodate individuals, but the problem is that they are not taking that obligation seriously. So they know they need to provide captions, they know they need to provide equal access, but they don't really make sure that their captioning devices are working. They don't put policies in place to make sure that there actually is equal access. And I think that's a big kind of area that I see that needs to be corrected, because it's not so much like we're not gonna do this, because they have to. It's more just the way they're implementing it. That's another area where I see this come up a lot. Um, I think those are probably some of the big ones. I'm sure I'll come up with other ones. I know another one is jails. Hopefully that's not an issue for any of you, but we see a lot of issues with accommodations in jails and with the police. That can be a big one as well. I think those are kind of the main points that I wanted to talk about in terms of my experience with Denver. I can I can give you guys a few other interesting cases that I've worked on. I'd love to kind of talk through them with you. I'd also like to sort of open this up to talk about any issues that you guys may have, and try to answer questions that you may have. I think that may be an effective use of some of the rest of our time. It looks like Maggie had a question.
I do. I wanted to ask you, I know part of what we do at the ADA Center, we're not an enforcing agency. We're an information resource. So we, refer people and let them know when discrimination occurs, what they can do about it. And of course, hearing issues is a huge issue. I mean, I'm preaching to the choir also, but I'm curious. We would normally, the first thing we would do is refer somebody to the Department of Justice to file a formal complaint, which I'm sure you're aware of that. I, what did you consider that? And it doesn't sound like that you're going to proceed that way, but I'm curious as to what your take or your comments about filing with Department of Justice.
So I am actually very happy you brought that up. So first and foremost, if you or any of you are working with an individual who is struggling to get accommodations or experiencing some sort of discrimination from an agency in Colorado, I think you've probably all heard this before, but number one, get evidence in writing, get an email, get a recording. Colorado is a single party consent state, which means that if one party consents to a recording, that recording is admissible. The one party consenting to the recording can be the party recording what is happening. So in Colorado, if you're having that issue, you can always just take out your phone and record it, and you're the one party that's consenting, and you're good to go. So make sure that you get the evidence and documentation. The second thing, Maggie, and I can work with you on this. Maybe, it may make sense for us to set up a meeting, or I could even come up to Colorado Springs and meet with some of the people in your office. But I would highly, highly, highly encourage people to file charges of discrimination with the Colorado Civil Rights Division. And go ahead, Maggie.
And I want to say we do also refer folks to the Colorado Civil Rights Division. We do that a lot of times in tandem, because
Yeah.
one can be a little bit quicker than the other. My understanding, though, is that the Colorado Civil Rights Division does not file against another state entity. Is that incorrect? I know they can
So
with a private company or private business.
no, they can file against another state entity. And I would, if possible, I would try to encourage individuals to file with the Colorado Civil Rights Division over the Department of Justice. Maggie, I think in some cases, if it's sort of habitual discrimination against like a deaf individual, and it's a company like UPS or a nationwide company, then you may want to file with a federal agency just because they will have had probably lots of complaints from, deaf individuals related to that issue. But in my experience, and I've done a lot of this, the Colorado Civil Rights Division is far more effective at getting individuals to an early resolution. And what is super helpful is when people file with the Colorado Civil Rights Division, one of the first things that they will do is ask the parties if they want to go to mediation. And here's what happens, just from a practice pointer. What'll happen is if the party is unrepresented and it's a disability discrimination complaint and they want to go to mediation, and their complaint is more about like, we want them to change their policies, respondents will almost always say, yes, we want to go to mediation. And if they want to go to mediation, you can tell them to call me and then I can represent them just for mediation. And it can be so effective because one, like, once a company or an organization makes a commitment to say, I'm going to go to mediation, knowing what the claims are in front of them, they're already kind of making a decision that they're going to pay some money and that they're going to make some changes. And that is usually a situation where like I can come in and really work with them to like kind of push that as far as we can to make sure that we're getting as much injunctive relief and as much money. Usually it's not going to be a lot of money for a mediation. But it's a very effective way to try to just push the envelope and get companies to make as much change as you can. So Maggie, like again, not every case can be filed with the Colorado Civil Rights Division, but almost every case that you could file federally, you could file under the state division as well, because you have employment claims, which are covered by the Colorado Civil Rights Division. You have housing claims, which are covered by the Colorado Civil Rights Division. Then you have any public accommodation claims, which are also covered by the Colorado Civil Rights Division. And like literally any public accommodation. So any company, state entity, anything that puts themselves out there as providing services to the public, the CCID is going to have, Colorado Civil Rights Division is going to have jurisdiction over those claims. The only thing that you have to know is that for public accommodation cases, the deadline to file is 90 days, 90. So if it's a situation where like it's a movie theater and they're not providing accommodations, or it's a doctor's office and they're saying you have to bring your own interpreter to the doctor appointments, or they're trying to charge you for the cost of an interpreter. If it's a situation like that, to get that into this CCID process, you have to file right away. And that's so important because the challenge that a lot of people will have is they'll come to me and they'll be like, hey, Spencer, like I had a doctor's appointment and the doctor made me pay for, an ASL interpreter for that appointment. And I'm like, as much as I would like to take on every single one of those cases, I just can't. And what I have to do is I have to tell the individual, okay, look, like, we can do this and we're going to win, but you have to pay me my hourly rate until we get to that point where we're winning. And if they decide to push back and fight a little bit, at $4.50 an hour, that adds up very quickly. And it makes it very difficult for a lot of individuals to be able to even afford the fight. And even if it's a case where I'm like, I know we can win this, like I have to look out for like the business that I have. And so that's why I think it's so helpful and I think it's so important to make sure that people know that they can file that charge and get it within that division, because like one, now you have like an agency that's going to investigate, and if it's a clear-cut case, they're going to find discrimination and they're going to force you to go to mediation. And then when you go to mediation, like that's a situation where I can easily step in and be like, okay, we can get this done in a half day. You're not gonna have to break your bank to try to like get to a resolution of the claim. So, thank you for bringing that question up. I mean, I
Thank
think that's
you.
just super helpful, and like to the extent that like you're referring people to me or to file charges, like I would just highly encourage you to send them the information about filing a charge with the CCID.
Thank you. I appreciate that.
Yeah. Do we have any other questions?